Good evening, everybody. Welcome. I want to call this workshop to order. I know the mayor's going to be joining us online shortly. I don't know, Madam Clerk, if he's here already or not.
No, I don't think so. I do have two participants online for public comments, but I don't see Mayor Sid still.
Okay.
Actually, only one.
Before we get started, I know we
Yes.
just had a presentation by the Public Safety Committee, and wanted to thank them for honoring our law enforcement and firefighter personnel. So thank you so much, Chairwoman Rogers, and thank you for the presentation that you gave. With that being said, I'd like to jump right into the workshop, and if we can go ahead and hear those public comments that are online.
Absolutely, Vice Mayor. Welcome to the workshop of short-term vacation rentals. I am aware that we have at least one participant via Zoom. Please state your name and address for the record. You will have 3 minutes, and we welcome your input. I still see the participant. If you're for public comments, please unmute yourself and just state your name and address. Vice Mayor, I know that we have a person who called, but again, we're not aware if that person is just calling to listen or if the person wants to participate.
I'm good. It's more relaxed format. It's a workshop, so if somebody chimes in online, I'm pretty sure we'll be more than happy to accommodate. Moving on, is there anybody in the audience for public comments?
And for purposes of the record, I do see Councilmember Rodriguez has joined us. Welcome, Councilmember Rodriguez. Good to have you.
Thank you very much. I'm a little late.
Good, thank you, Councilman Rodriguez. Thank you for joining us. Mr. Blanco, you're recognized.
Yes, good evening, Council. Eddie Blanco, 6290 Lake Champlain Terrace. This item is regarding, I wanted just to speak about the item regarding the vacation rentals. I realize that the vacation rentals are a concern for some of the community members. I don't think it's as big an issue, or I don't think it's as widespread an issue as to bring something so invasive as home, inspection inside the property. That's my biggest concern with it. I think that the real issues that I've heard of, in fact, one of my associates has a nuisance property behind him, and the issues are really noise, which is already covered with noise ordinances, and cars parking, which is already covered in our ordinances. So the issue is really a code enforcement issue, not so much is the property being used, with multiple units or whatnot. So as the issue relates to the inspection inside the unit, why don't we just force the owner, right, to prove that they have relinquished their homestead exemption? Because you're not going to relinquish your homestead exemption if you live in the property and also have a little efficiency that you're doing Airbnb. So by relinquishing their homestead exemption is a big expense to them, and that solves that issue. I think I'm concerned about the inspection of the inside of the property as well, because then the town, I think, by doing that kind of, is like certifying the safety and well-being of that house. And should we be doing also inspections on, is it unsafe to rent a house for 6 months? Is it unsafe? Are you caring about the tenants that are renting a 6 month or 1 year? We have those safety concerns as well, right? So those are some of the things to consider. I like the idea of, knowing who they are that's renting these properties. And maybe consider, I know that Miami-Dade County does a drive-by inspection just to do a visual on the outside by a city inspector or county inspector. to, see that there, isn't any obvious concerns, and or that they're complying with all the other ordinances. I don't know I haven't seen a revision of the last, I would like to have seen a revision. I don't know if there's one available. So that would have been good, so I can provide some public insight on that. So those are my comments. Thank you.
Thank you, Mr. Blanco. Anybody else wishing to speak on this item while we're in public comments?
Hi, I won't take too much time. I think there are others, hopefully. Oh, okay. My name is Danielle Blake. I work with Miami Realtors, and I just came to share some information with you. So we have 50,000 members here, over 4 counties in South Florida. We're very engaged on many issues. Florida Realtors has a very, very strong position on private property rights. And the reason why I say Florida Realtors at the state level versus Miami at the local level is because we do have members on both sides of this. We have pretty much a 50-50 split, whether we poll the members or we're polling the leadership. Some of them feel absolutely this private property rights, you shouldn't do anything. And the other half, because we're in an urban area, they do understand the concerns of having, the party houses and all the bad things that you hear about. However, what everyone agrees on is the inspections that he just talked about, going into the property. And so as we mentioned, Miami-Dade County, they do a drive-by inspection for theirs, but they never go inside the property. And so we do, stand for private property rights in that sense, and would like you to remove that from the proposal. Thank you.
Thank you for the public comments. Anybody else in the audience wanting to provide public comments before we start the workshop? Going once, going twice. Okay, we're going to close public comments at this time, and I'm going to turn it over to my colleague, Councilman Fernandez. This is your item. We're here to support you, and I'm going to turn over the floor to you.
Thank you, Vice Mayor. So to kind of rewind and go over the intent of this item, is for us to be able to regulate properties that people want to use as short-term rentals. Popular platforms like Airbnb and VRBO, for those that may not be familiar with what I'm talking about. So I've had discussions with both the attorney and with staff. I think they both have some potential improvements to the ordinance as written. So I'm gonna go ahead and let them present, and then we can kind of circle back.
So I think we're going to take it from here. I want to introduce John Breyer. He's the one that is helping us with this endeavor, and he has prepared a very interesting presentation that hopefully will clarify the conversation so that it can go in a direction that we can find some common ground to find the middle where everybody can meet. And I hope you guys appreciate it.
All right, thank you. Are we going to get the PowerPoint? Hello? Yeah, no, I think the mic.
Ariel, can you please put up the PowerPoint? Great. Can you start it at the beginning, please? Yes, no, that's not.
That's fine. We missed my little intro page with the Miami logo, but that'll work. Oh, there we go. There we go. So forgive me, it's my first time working the clicker. Of course. Here we go. All right. So welcome, everybody, to this workshop. As you know, or as many of us know, there's already been some hearings on this. An ordinance was presented. But this workshop is an opportunity for us to take a step back and kind of look at the bigger context here. And that's a lot of what this presentation is about. So the presentation is going to be in 3 parts. I'm going to be introducing short-term rentals just to make sure that we're all on the same page. And that's also going to include a presentation on the legal framework by the town attorney, Mr. Coviela. All right. We've done a lot of research on this issue. There's a lot of research out there. Obviously, this is something that's been happening for over a decade. Into what we know about the effects of short-term rentals. both at a larger scale and also at a micro scale. And we're going to conclude the presentation by kind of setting the stage for our esteemed council to kind of discuss and for the public to opine by kind of discussing how we regulate short-term rentals, what the options are, and what's been done and what's the effects. So that's what we're doing in this presentation. So we thought, based on comments from previous public hearings, it was important to ask, what are we even talking about, Now, this is, we don't want to be angry and confused talking past each other, and when we, it's important to understand what it is that this ordinance is about. So here's the wording from the originally proposed ordinance. Now, keep in mind, part of this workshop is for that to be, worked on. The final product will very well be different. But this is important. There's 2 points here. A vacation rental, and this is based, we didn't just make this up. This is based on the Florida statute, and all the local municipalities across the country have pretty much the same wording. So, we're not talking about, hey, I want to rent this for 3 months because I'm away for the summer. This ordinance doesn't apply to you at all. Vacation rental, the legal definition is you're either renting it for periods of less than 30 days or you're advertising it out to the public as a place that's regularly rented to guests. So that's the purview of this ordinance, just so that we're all on the same page. Now, I think the clicker went. Yeah, I think the clicker malfunctioned. Maybe it's out of batteries. Maybe we didn't check the batteries. But anyways, in the absence of the beautiful graphics, I'll just pick up where the presentation left off. So another big concept in this introduction before we get to our, here we go. All right, good. Are we there? Oh, excellent. So another big concept that we wanted to make sure that, we all were on the same page about was, already the laws in the books regulate what you can do in your residence, right? I mean, if you want to cook food for your family and friends, you want to cut your daughter's hair, there's a lot of activities. You can even run a business from your house if you're just pushing papers around. But there's already activities that are not allowed. If you want to open a hair salon, a restaurant, a clinic, I mean, these things are already regulated and they're not allowed in single-family residences. There's a legal framework, which our town attorney will get into, but there's already issues here, and there's already things that are regulated and we can't do in our homes. So, when we look at these pictures and kind of just set the stage here as we listen to this presentation, we have a hotel, we have hostels, bed and breakfast. These homes that are being rented out as Airbnbs, other than not having the sign on the front of the house, well, we have to think about and reflect on what really functionally is the difference, and are regulations appropriate? So that's probably a good time to pass it off to our town attorney, Mr. Coviela, who's going to discuss the legal framework.
Thank you very much, John. And just quickly, I wanted to apologize for our late entry. We were on a call on 59th Avenue. Mr. Gastesi, Councilman Rodriguez, and myself, we've got a meeting tomorrow, so I apologize for the late entry, but we were deep in conversation. I also want to thank Susanna and John. It's been wonderful to work with John. Susanna is not only a fantastic planner, but she's got an eye on talent, because he's a very bright guy, and we're very happy to be able to work with him. So with that, I just want to give you, Council, a brief overview of Florida law and short-term rentals. Next slide. Oh, does the clicker work? Oh, it's working now. Okay, great. All right, so we're going to start at Florida Statute 509.013. In this section, it's funny how the legislature kind of tagged what are public lodging establishments with food establishments, and they kind of placed them both together in one statute. And basically what they do when they're discussing lodging establishments, similar to what John was saying, is there's two types. There's a public lodging establishments means any unit, group, or dwelling building, group of buildings within a single complex of buildings which is rented to guests more than, again, like John said, 3 times in a calendar year for periods of less than 30 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place of regularly rented to guests. Now, there's two types of, that's transient public establishments. There's also what's considered non-transient. Sure. Okay. Absolutely. No, no. Okay. Okay. All right. So we've got transient public lodging. We're also discussing here what are non-transient public lodging, and it means any unit, group of units, kind of same definition, but for periods of at least 30 days or 1 calendar month, whichever is less, which is advertised or held out to the public as a place regularly rented to guests of at least 30 days or 1 calendar. So it's got two different definitions, but for the purposes of the council, right, what you need to understand is that this includes the Airbnbs, this includes those different types of websites that are announcing and to the public that, listen, you know, my house or my room is up for sale, is up for rent. You can come, you can rent, you can fill out an application and stay at our home. And some of these are done on public websites, and some of these are done personally, you know, person to person. But the key here with both, as we're going to see, is that they're regulated by the state. A person can't just automatically decide, I want to rent my house. I want to put it out on the market. It has to go through a process. And this process, Florida statute provides the actual process. Section 509032 lists out duties. And it says that the Division of Hotels for the state of Florida, and that's what the division is, shall carry out all the provisions of this chapter and all other applicable laws and rules relating to the inspection, okay, or regulation of public lodging establishments. And then they put public food, which is kind of funny too, but like I said, for the purpose of safeguarding the public health, safety, and welfare. It says, the division shall be responsible for ascertaining that the operator is licensed under the chapter, does not engage in any misleading advertising or unethical practices. Inspection of premises. The division has jurisdiction and is responsible for all inspections required by this chapter. The division is responsible for quality assurance. The division shall inspect each licensed public lodging establishment at least biannually, twice a year, except for transient and non-transient apartments, which shall be inspected at least annually, once a year. So all public lodging, hotels, once a year. If it's Airbnbs, which are the transient, non-transient apartments, once a year. Each establishment licensed by the division shall be inspected at such other times as the division determines is necessary, again, to ensure the public health, safety, and welfare. Next, if during this inspection public lodging establishment classified for renting to transient, non-transient tenants, an inspector identifies vulnerable adults who appear to be victims of neglect, or in the case of the building is not equipped with automatic sprinkler systems, tenants or clients may be unable to self-preserve in an emergency, the division shall convene meetings with the following agencies as appropriate to the individual situation. Department of Health, Department of Elderly Affairs, Fire Department. In other words, the state shall convene and shall contact these different departments. And this is an area of the law where we as a municipality can, you know, make sure that our code inspectors are making sure to readily go out there, and if we see something, be able to, through the agency, contact and make sure that these inspections are being done or that these agencies are being contacted. And that's something that later on you can discuss, and I'm sure our planner will go into. This is the part that we're all not going to like, right? Preemption authority. The state, by creating this section of Florida law, has preempted local governments from making any additional rules unless the law was established prior to the year 2011. So any laws that we have currently on our books that regulate these lodging type of activities, we can go ahead and put together in a section of the code and make sure that we are enforcing. However, we have to be careful that not to create additional rules and regulations that would go against this section of Florida law, because the law with regards to lodging, short-term rentals, has been preempted by the state. Now, that doesn't mean that there's not things and mechanisms that we have at our disposal. There's stuff that we have. Florida Section 509241 says that each public lodging establishment and public food service, again, shall obtain a license from the division. Such license may not be transferred from one place or individual to another, and it's a misdemeanor of the second degree, punishable as those two statutes, for such an establishment to operate without a license. And here's a good part. Local law enforcement shall provide immediate assistance in pursuing an illegal operating establishment. Second, application for license. Each person who plans to open a lodging has to apply. And third, display of license. Any license issued by the division shall be conspicuously displayed in the office or lobby of the licensed establishment. So in other words, these establishments, again, like I said, just can't open. Just can't say, hey, look, we're going to allow our house to be a place where people can rent out for a month and have a good time while we're living someplace else. No, that's not the way it works. If they are going to operate as an Airbnb or as one of these short-term rentals, they have to get licensed, and that license has to be up and visible to anybody who comes into their house, their residence. Second, another very powerful tool that we have, Section 205053 provides for business tax receipts. As a municipality, we have the right, and I would say the responsibility to make sure that these operators have obtained a business tax receipt from the town, and also that this business tax receipt is placed conspicuously at the entrance of these residences. And again, if they're not, the statute also provides the mechanisms for us to be able to enforce that, and the failure to have that. Zoning. The planner is going to talk to you a little bit about zoning, and there are things that we can tweak in zoning, but the AGO, in a recent opinion, not so recent, it's a 2014 opinion, but she does discuss, there have been municipalities that have tried to use their zoning powers to curtail short-term rentals. That's not something that we really can do. Short-term rentals have to be allowed, and that's something I want you to understand. While we do have the enforcement mechanism, and we do have great zoning already in the books, which our planner will discuss with us, at the same time, we can't use our zoning powers to make short-term rentals so restrictive that there will not be allowed in our town. So we have to be very careful. This is very similar to other conversations we had with regards to community housing, which we had a couple of years ago. This law is very, very similar in that sense. And with that, I think I'm done. I'm done. All right, so with that, you guys have heard what you can do. I mean, sorry for saying you guys. Apologize for that. That you council members have understood what you can do, what you can't do. And now for the fun part, I'll leave it to my esteemed colleague. Yes?
Before you leave us,
Yes.
and because it's a workshop, can we just openly ask questions? Thank you,
Absolutely.
Vice Mayor. With regards to the division that is stated here, which is the division of hotels,
Yes.
this is the division that would be conducting these inspections, and so then this is already on the books. So if someone had an Airbnb, a property that they are renting, they would have to be licensed by
Yes.
the division of hotels, and they would have to either be inspected annually or biannually.
That is correct, Councilwoman.
Understood. Thank you.
Yes. And as a municipality, similar to, we had a situation with the community housing where they were operating a sober home type of operation, right? So as a municipality, we contacted the correct agency. I think at that point it was the Department of Children and Families. They went out there, they conducted their inspection. So we as a municipality, obviously, if we think that there's something going on, can contact the division and ask them for an inspection or for records of that inspection.
That's even if we don't have anything particularly, we don't have an ordinance of the town with regards to this, we still have the tool, which is to contact the state and contact the division of hotels to go out and take a look at a property that we think is an Airbnb or that we've received complaints about?
Sure. So something that, just thinking out loud, right? So we want to create an ordinance and something that we can do. We could, hypothetically, make through our BTR process, if they don't renew the BTR, make sure that code enforcement not only goes ahead and cites them, but automatically contacts the department and asks them, hey, this person hasn't renewed the BTR. Have they renewed their license? Have you conducted the inspection? An idea.
Okay, understood. Thank you so much.
Any other questions? Okay, so I'll let the fun begin and pass it on to my colleague, Ms. Alonso.
All right. Hello. Excellent. And actually, to expound on Councilman Ruano's question, you know, it's very common for local ordinances and through the BTR process to require that when you renew your BTR every year, you have to submit the documentation showing that you've fulfilled all the state requirements, right? So all of that, you know, typically someone who wants to run one of these businesses, they have to deal with the state, and then typically the local is going to require all that state documentation every year to make sure that it's up to date. So that's one of the benefits of having the local ordinance, the local BTR process. But
I have a follow-up question. How many of these homes are registered through the state right now here in the town of Miami Lakes?
ooh, that's a good question. We don't have that number at this time, but that's definitely something that we can look into. I mean, we've been anecdotally made aware, of course, Councilman Fernandez, but as far as an analysis of it, we don't have that at the moment. Susanna?
Sure, I'll just borrow this one. We do know that we have several, somewhere below 10, but more than 5 short-term rentals currently actively active in the community. We do not know whether they're registered, not registered, whether they have gone through the state procedure or not. That is not something that we're even engaged to do right now because we don't really have a procedure for it. So it's not something that we go out and do of our own free will, right? Until we do have a procedure for it.
It was just something that came to mind because Mr. Kobiella mentioned when we were dealing with the community residential home issue. I remember one of the things that we did was to actually get a lay of the land. We looked at, how many of these places are licensed through DCF, how many are licensed through the Agency for Healthcare. It helped us kind of gauge where do we sit, right? So if there is a mechanism through the state that already has this registration process, I think one of the things that would be helpful to us to see where we sit is where are they located. I think that's one tool, and then the other tool is use the VRBO, the different peer-to-peer sites, and it might give us 2 different lists that maybe somebody might be. Is it to list your home on VRBO? And I apologize, I don't know that system. Are you required to show proof that you're registered with the state?
No, I don't believe so. Now, also, the issue of monitoring is also very complicated. I mean, nowhere are people, like keeping track of who's listing on Airbnb. I'm aware, based on my research, there's limits to how much Airbnb actually shares with the government as far as that information. I with your point that some of these local municipalities that regulate this, obviously, they're looking online at the Airbnb listings, and they'll often have a requirement. That's one of the available tools that, you put your BTR number when you have the online listing. So obviously, this is a business that takes place largely online or that's mediated online. So monitoring, enforcing it online and having it, having the transaction makes a lot of sense from a regulatory perspective. But big picture answer to your question, I think it's, my understanding is it's just very difficult to monitor. We don't have that information. I think it's very difficult.
Other than having a procedure by which we ask the applicant themselves. Right now, basically we would be calling the state, calling the state to ask them, what do you have in our municipality? Do you have anything? Right, so it's a little bit like fishing expedition. When you are actually, or literally going down the thing and say, hey, do you have this one? Hey, do you have this one? Right, which is a little backwards than it should be. Technically, it's better when people bring you their information themselves. So here, I'm coming to register. This is my information. This is when the last time I did my inspection. This was, I registered on this date, and this is, right? So this is when I follow my procedure, and that's a little cleaner because now you can keep all these files and be ready to accept them, yeah.
Right, and also, I think, in our opinion, or, it's not necessarily about a perfect, kind of what I'm going to get to a little bit in the presentation, perfectly regulate this, but by just having the ordinance in place, having we can make more than an incremental difference in sort of address the mic's kind of on the fritz. All right, so
John, excuse me, I just wanted to make one point. Going to what we're discussing, Vice Mayor, is, and that's why I kind of want to give you the lay of the land as far as the law is concerned. And the law, I think, is very favorable to local governments in the sense that it provides us that local law enforcement can go ahead and enforce if someone is violating and doesn't have the correct licenses. It allows us to require a BTR, and it requires that, and it makes it actually a misdemeanor if one of these operators are operating without these particular licenses. So I think that the mechanism and the idea as far as the legal framework that I want you all to keep in mind is we want to make sure that the BTR process for these hotels are being, first of all, asked for, that they're being enforced. In that BTR process, they have to provide us with a copy of their license, because if they don't have a copy of the license, they can't be operating. We can't be giving them a BTR. And if they don't have a BTR, they're obviously violating the law, and they might be committing a criminal act as per the statute. So that's something that in creating the ordinance, we're not creating new law, but we're just kind of putting it all together in an organized fashion. So as far as the legal framework, I just want to make sure that that's your takeaway from that part. And then as far as the pretty part of what we can do, that's for John.
all right, so now that we've, and I'm sure we'll get back to the legal framework as this is open for discussion, but yeah, I'm going to get back to as our town attorney said, the narrative, kind of setting the scene, the storytelling part of this workshop. Many people have said, there's always been short-term vacation rentals, right? And that's true. Even before the internet, people were doing this on their own. And even, there's been peer-to-peer rental websites like VRBO. VRBO was created in '95. So those have been around for a long time. But I think, as most people are aware of, the real game changer was Airbnb. They were founded in 2008, and Airbnb has had explosive growth. It's now the largest tourist accommodation marketplace in the world. I saw the statistic. They actually have, their inventory is 8 times the size of the Intercontinental Hotel worldwide. So a lot of this issue that's on us now has to do with the proliferation of Airbnb, which has led to all of these short-term vacation rentals. As you see there, over 2 million people stay at an Airbnb per night. 6 million properties listed worldwide. So there's a lot of positives to these short-term rentals, to this new business model. The research shows a large part of the appeal is people don't necessarily want to stay at hotels, and hostels. They want that authentic experience of staying in a local neighborhood. Also, opening it up, there's all different, it's not one size fits all. People can go to different types of lodgings according to their personal preferences. That's kind of where, our modern times are trending these days. Additionally, hosts through Airbnb are able to offer competitive pricing. But, we know that a big part of that is because they're not subject to the safety standards and the regulations that hotels and hostels and these other professional commercial establishments are subject to. So let's put a pin in that, and we'll get back to that in a minute. Whoops. Okay. Now, once again, like some of our residents have voiced in previous hearings, Airbnb, the ability to list your property can be very positive. It allows residential property owners to basically become hospitality entrepreneurs, and it's for basically the little guy, or not a large corporation, but someone who wants to rent their own house for some period of time and wants to make some additional income. This can be a very positive thing. Even from a macro perspective, this is good, because the ability to open homes to visitors supports sustainability. We can, these houses, you're leaving on vacation, the house is vacant, you want to rent it. We're basically encouraging higher house utilization rates without having to build additional inventory. So that's there's a lot of positive aspects to this technology and what it's brought about. Oops. But There is a lot of research on this subject, like I was alluding to before, and I just want to quickly go over that before opening the floor to discussion. What have been the effects of this rapid increase in short-term vacation rentals? Well, one of the cruxes of the issue here is that short-term rentals, which may be obvious to you or not, they earn a higher rate of return compared to medium and long-term rentals. All right, so as a consequence, you basically, for people looking to buy investment properties, and this is a trend that I've seen in the flesh, and we know is happening in South Florida to an extreme degree. It's more profitable for an investor in residential property to run it as a short-term rental. And so what that basically creates is a situation where, as we're taking residences off the market and renting them to tourists, there's less housing available for local residents. So the macro effect is that it's raising rental rates, it's raising the housing market. Now, if you're an owner of a single property home, you may say, well, what do I care about rental rates raising, or it's not my problem, or hey, maybe we'll even have better tenants in our town because the prices are higher. But the reality is that the same people are going to be here. What's going to happen is you're going to have people rooming with each other as these prices go up. So you're having more people in the same units. And so you're putting a stress on parking, you're putting a stress on traffic, and basically more people are cramming into these places that are intended, and the infrastructure is available for fewer people. We know that's already happening at a local level. All right? So in tourism-heavy cities, which ours is, and by ours I mean Miami Lakes here, we're in the backyard of obviously a very heavy tourist city, and as I discussed earlier, that's a lot of what people are looking for, right? People that don't necessarily want to go to a hotel in Miami Beach. They want to stay, a big group wants to stay in a single family home. Let's not kid ourselves. Miami Lakes is very much a target for these short-term rentals or an appealing destination. And we know that in tourism-heavy cities, this effect is even more pronounced. Rental rates have increased as much as 50%. In fact, this article is from last week. South Florida is now becoming the nation's worst place to rent. Now, obviously, there's many big picture factors that go into this, but, in our educated estimation is there's no question that Airbnb and the proliferation of short-term rentals reducing housing supply for other uses is part of this problem. All right? Now, on a more micro level, we know, and this is obviously a complaint that's been voiced by some of the town residents, a high concentration of short-term rentals, it changes the character of a residential area, right? And I think this is something that appeals to everybody's common sense, but of course it's something that the research bears out. And now it's very complicated studying, specifically short-term rentals, separating them from longer-term rentals. Probably a lot of that research will be clearer as more time passes, but what we already know, just as a basic truism, is that higher rates of tenancy lead to higher crime rates. So it's very obvious, rental neighborhoods that are primarily rental neighborhoods have higher crime rates than single-family residential neighborhoods, and so we know that when we're going to have the proliferation of these short-term rentals in a neighborhood, it's very logical that it's going to increase the rate of crime. So a lot of what the research shows here is the bottom line, it's about accountability. Nobody is saying that it's intrinsically bad to rent out a property on Airbnb, but in the absence of regulation, a lot of the problems that exist with rental slumlords, absentee landlords, these are when these situations can get out of hand, when there's no regulation whatsoever, in order to keep people accountable. Because, like I mentioned before, this is an extremely profitable business. For an investor, short-term rental is the most logical course of action for their residential property. And so we think it's wise to have some level of accountability in order to keep that in check. It's kind of maybe a slightly exaggerated graphic driving the point home, but there it is. We don't want that. All right, so you might be asking, well, why now? Why are we trying to regulate short-term rentals now? Why is this being proposed? Well, in fact, we're actually behind the curve as far as local municipalities go. So I know Mayor Sid mentioned last night that our most comparable municipalities are Cutler Bay and Palmetto Bay. You can see there's a list. Most of these have had an ordinance on the books since 2018. So that's not an exhaustive list. That's just a few examples of municipalities that are close to ours, similar to ours. But most of the municipalities in South Florida already have started to have these ordinances on the books, and in terms of their structure, they're extremely similar to what was proposed, even if that doesn't end up being the final product. Now, I just wanted to share this. I own a condo, and I got this flyer in the mail a few days ago. It's advertising from a company that wants to manage your property as a vacation rental. So it's not the first time I've received something like this. It just speaks to the fact that this is something that's very ascendant, and we can say it's not a big problem right in this moment, but from our point of view, part of planning ahead for this is seeing the slippery slope that's coming, and especially in light of if we're a safe haven that doesn't regulate it at all, and all the municipalities around us are regulating it, that's potentially problematic. I mean, there's no question that this is a very profitable activity that everybody's trying to get in on. And we know there's also, Miami Lakes is close to development that's going to happen possibly, in the near future. That'll even be make it more of a magnet for tourist and subsequently Airbnb accommodations. We also know this is something that, people have a common sense of, but especially with being able to work remotely, I think that's a trend that was exacerbated, kind of moved further along by the pandemic. That even generates more demand for these short-term rentals. So to wrap it up, what the planning department is recommending is to regulate short-term rentals, specifically in Miami Lakes, for the following three main reasons. We want to keep our residents safe. We want to keep the visitors safe that are actually staying in these Airbnb listings, and we want to maintain the residential character of our neighborhoods. So with that said, appreciate you guys coming along for the ride, and let's open it up to commentary.
Thank you. Councilman Fernandez?
Excellent. Thank you, Susana, and thank you to John for your presentation. Couple things I also wanted to mention, and I think you opened the why now conversation. Another kind of thing looming on the horizon. This was almost the ordinance that was not during the last session of the Florida legislature. There was a bill to completely preempt any sort of regulation, and that bill kind of morphed, and most of the aspects that would have stopped us from doing this went away, but that is just one session away from coming back. So what I would hate to see is municipalities around us having these ordinances. And by the way, when the state was thinking about preempting it, it would have left in place, it would have grandfathered in any existing regulations. And so what I would hate to see happen is municipalities around us have these ordinances, we don't, all of a sudden the state preempts us, and we become the safe haven for short-term vacation rental, the destination in Miami-Dade County for short-term rentals. And that's part of trying to be proactive. I understand that the number now is less than 10, but I think that's right around the time that we have to start addressing it. I don't think we want to address it when we have 300 operators or 500 operators. I think we want to set the rules and make sure that everybody's operating within those rules early on. Obviously, when people operate in a certain way in the absence of rules, it's always a lot more difficult to get them to comply when the rules are there from the beginning. It's a lot easier process. So that's really kind of the motivations behind the now, at least as far as I'm concerned. Definitely heard the input from both of our public speakers, and I think in line with what the attorney said, I think we can forego us contemplating our own inspection of the premises. I think we can, during the BTR process, just require that they present proof that they licensed with the state, and whatever inspection process the state has would be sufficient. I think that allays some of the concerns, and I think that makes sense. If there's another agency already conducting these reviews, no need to duplicate efforts. So that, I think, was probably the most contentious of the aspects. Is there anything else in the ordinance as presented that any of you have an issue with?
Councilman Fernandez, I believe the clerk distributed to us some recommendations. I think these are being proposed by Councilman Dieguez. Councilman Dieguez, if you want to expand on what the clerk distributed to us, I believe Councilman Fernandez may be open to some of your feedback now.
Thank you, Mr. Vice Mayor. And what was passed out to you was basically a sort of model code that was, that came out of a meeting back in 2018 that I had with the Airbnb lobbyist at that time when I was looking at doing this. And ultimately, as I stated before, I backed off because we had less than 10 hosts in the community. So it seemed to be trying to approach, trying to take a bazooka to an ant pile, right? So it just seemed a bit much, and that's ultimately why I let it go. Listening to some of the comments made by staff tonight and some of your points about preemption and not having our own code, I'm willing to look at reasonable regulation, which is why I said, look, I will workshop, or if you agree to a workshop, I will work to make this something that I can live with. And that's what I'm here to do tonight. So, again, this is just more kind of like there for reference. Specifically, though, as far as the challenges that I saw with the ordinance as presented, one of those things that I have an issue with is I believe it's page 396, in subsection 5, the responsible party is basically required to respond to an emergency call within 2 hours of notification. I'm not crazy about that. I think most of the issues that you're going to be having, whether it's a wild party or a parking, a trespass caused by somebody parking on somebody else's lawn, I think that you don't need the responsible party necessarily to respond right then and there within a 2-hour window. And then I think that also creates other issues. Let's say they oversleep, or because they put their phone on vibrate. When this occurs at 3 a.m. I don't know. I just don't want to put owners in jeopardy just for stupid technicalities like that. Stupid circumstances that otherwise would have been easily avoidable. But here we are, basically whacking them. So that's something that at least I find problematic. That requirement that the responsible party has to respond within 2 hours of notification. And then, let me see here. I'm going through my notes that I made to the ordinance.
Councilman,
Sure.
before you go there, so how do we reconcile that with the sample ordinance? For example, section 2CB. Requires name, address, and email of emergency contact number of responsible party for the rental, which shall be 24-hour, 7-day-a-week contact number.
Yeah, at least the way I would look at it, again, this is something that was presented as a model thing, doesn't mean that it's necessarily the only standard to judge against. My perspective would be, just that they have to respond, within a 24-hour, window. I think that's more than fair. They wake up, again, I'm more worried about the situation where they don't answer in 2 hours, that's a violation, and it was something that happened at 3 in the morning when they're either not unavailable for whatever reason, and then now, because again of a technicality, they're in violation, and they're subject to whatever penalties the ordinance would impose. So that's why I think a 24-hour window is more reasonable, for them to, to get back to us. And again, most of the issues that we talk about, the parting and all that, our cops deal with that on a daily basis, or not daily, but on a on a probably a weekly basis on the weekends. You have noise complaints after a certain time, because our noise ordinance kicks in. So I'm trying to fathom a situation where the responsible party has to be available in 2 hours. I guess what I'm saying.
I'm fine with responding within 24 hours. I think that's fair.
Okay, perfect. And then remember one of the bigger things that stood out to me that I mentioned had to do with a provision here, and pardon me while I look for it, that basically would have held the tenant, the renter, accountable for violations of the setback requirements, which I feel is more of an owner's problem. And like I said, let me identify it here. Okay, I believe this is it. Okay, yeah. So on page 399, sub 10, under other standards, it states the occupant shall be advised that all standards contained within the Code of Ordinances and land development regulations of the town of Miami Lakes, including but not limited to noise, setbacks, and stormwater, are applicable to the vacation rental and may be enforced against the occupant. I don't understand why. Maybe you guys could shed some light for me, but what would be the point of, in essence, advising them of these setback requirements and whatnot? Again, if they're only there for less than 30 days, I don't know what that solves. I don't know if staff has an opinion on that or not.
I'm looking for it. Can you repeat where it is?
Sure. It's 399, subsection 10, toward the top of the page. All right, just above
or page 14 if you have today's agenda.
Oh, yeah, no, I'm working off of, I apologize. Yeah, I'm working off of, thank you for that. I'm working off of the handout from the last meeting that we discussed this. So I apologize. You know what? In that case, let me go ahead and work off of that one.
Oh, I see. I found it. Yeah, I'm really not sure why that would be there at all.
Okay, and
I'm
that's what I
thinking
figured.
maybe parking in the setback.
I mean, again, I don't know, but that was something that I flagged, and that was something we were about to pass on second reading. So that's why, I wanted to pump the brakes a little bit and kind of,
There is
flag.
a good argument to be made that one of the things that we would ask as part of the BTR process is that the occupants are made aware that they're not allowed to park in the swale, that they're not allowed to be bringing out the garbage when it's not supposed to be out, and that they're supposed to bring back in do you see those little minutia that any resident would be aware of, and that an occupant, even a temporary one, would want to comply with, but may not be aware of because they're particularities of the town of Miami Lakes or of our municipality, and that kind of thing is what this is going to. I do kind of I can't find a reason for the setback to be an issue, and maybe I'm just lacking imagination right now, but right now I can't think of it.
Yeah,
Sorry.
Oh, sorry.
No, sorry, Tony. I guess when I read through it, I missed the setback part of it. But I understood that the occupant was to be aware that all of these ordinances or code enforcement issues would be enforced against the occupant, because the occupant is the one that's there. So if code enforcement drives by and says your car is illegally parked, you need to move it, it's going to be enforced against the occupant, because the owner is not there. That's how I interpreted this. Obviously, I didn't see the setback. I don't know if maybe an occupant isn't gonna
setback
build
usually
anything.
applies when they're gonna be building something.
Right, so maybe that word can be removed.
Hopefully,
but
they're not there to build stuff.
Hopefully.
It's-
Hopefully, I mean, they can get really creative. But the way that I understood it was that all of these things would be applicable to the vacation rental and may be enforced against the occupant, because the occupant is the one that is conducting this, is how I read it. And I'm sorry, Councilmember Fernandez.
No, I think what I'm gathering is probably what we should have is a one page and optimistic. Welcome to the town of Miami Lakes. These are some of our ground rules that you may not be aware of, right? There's no parking on the swale, there's no, and we can lay some of those out in a, one page document that that then we can ask the renter to provide or post or however we want to
And
attack
on that same note, we already require that they post a human trafficking poster that we required a few months ago, and that would go along the same lines. Then the requirement would be to post that poster, and we could provide the graphics of that so that we make sure they get the right language in there. Same thing that we would do with a human trafficking poster. So these two things would be provided at the time of the BTR and be part of the requirement that these things be posted.
Question to the Vice Mayor, and not to put you on the spot, man, but in Marco Island, the boat trailer issue, when I was staying with you guys over there, that notice of violation was issued against you or against the owner of the rental?
Interestingly enough, how Marco Island polices it, they put a notice on the door, and the expectation is for the occupant that's in that home to correct the violation. If it's not corrected, I'm sure it goes to the owner. But they posted and noticed it immediately, and that's what I found that was so refreshing with Marco Island, that they gave you an opportunity as well within 7 days to correct the matter. So clearly Marco Island is not Miami Lakes. I'm pretty sure that they're very well aware that they have a lot of homes there that are, the sole purpose is short-term vacation. So they have a very clean mechanism. So a code enforcement officer drove by, saw a violation, wasn't immediate to give something punitive, but rather a notice that was put on the door. So I know our code enforcement, I don't know how proactive we are, but I know we mail a lot of our notices. But in this case, it was something that was very clear, very visible. It was put on the door, and it allowed the person to immediately respond. So when you immediately corrected the violation, that's it. There was no other notice issue. There was no stamp. There was nothing. You corrected the violation, and you can even be as proactive as calling the officer, when that's what we did. We called the officer, said, hey, look, does this take care of everything? Yeah, absolutely, and that's it, case closed. So I think that's maybe one of the things that we could entertain, right, is somehow immediately notifying the occupants, because the bird, by the time the owner gets notified, again, and I think what Councilman Fernandez is trying to do is we're trying to eliminate the horror stories we've heard, right? And those are one-offs. These are not, I think for the most part, people who are doing this by registering their home and trying to do it the right way are not the problems that we hear of. The ones that we hear of are the people that are doing a terrible job, and even though they've upset the entire neighborhood, continue to do a terrible job, and they almost snub their nose at, I don't care. So it's not the people that are trying to play by the rules, it's the people that are kind of poisoning the well for everybody else that we're trying to address. So I think, I think Marco Island does it right, but then again, their code enforcement is giving the people who are there an opportunity to correct the situation.
Vice Mayor, I wanted to address what you mentioned. Under Florida law, we too also have to give a warning. The law provides that before you give a citation, a warning has to be given. Give you, for instance, one of the issues that's prevalent in our community are the issues of boats. Our code enforcement officers, if they see someone has a boat and it's illegally parked or it's been there for more than a certain period of time, they'll give them a warning. Hey, by the way, you're not allowed to have your boat. And sometimes, I mean, our staff is not huge. We don't have a huge code enforcement staff, but those that walk around, especially on Saturdays, that's what they'll do. And if they don't remove it, then afterwards, then yes, the citation comes. And if they're repeat offenders, then no warning is given, just a direct citation. So that's prescribed by law.
Is the notice given, like, placed on their door, or is it mailed?
Many times the officers will actually give it. If they see the person outside, they'll deliver the actual warning.
So my
Sometimes it'll
experience
be
in
placed.
Marco Island, when we got that notice, they gave a cure period as well of 7 days.
Yeah, that's
And then-
prescribed by law.
And then if you did not cure within 7 days, then action would be taken. So,
Usually, in most of our cases, it's 30 days that we prescribe for many of them. For some of them, they could be 7. I could get back to you on the exact time frame, but most of that is prescribed, again, by Florida law.
yeah, no, very good. Thank you.
The other thing that I think we should do when we clean up section 10 is I think whatever specific language in there should read and may be enforced against the occupant and or owner.
We could look into that. Thank you.
Yeah, and definitely the setbacks should be omitted. I don't think that benefits the occupant or in any way, or really achieves much of anything with respect to short-term rentals. How about the stormwater aspect? I'll wait a second. I apologize. Through the chair to the planner, it also talks about stormwater, that the occupant will be advised of standards related to stormwater. What would that be?
Well, that would be appropriate, because that would be if they're blocking somehow drainage of the water from the roof, or they're deviating water from, when you're occupying a house, you may be running a hose, and instead of allowing it to drain into your property, or maybe decide to drain the pool and start draining it onto the right-of-way. So yes, we would not want them to encumber our stormwater system with whatever drainage from the property, which is required by code to be maintained within the property. So yeah, that's one of those that makes sense. The setback could be, if they, and Mr. Peterman was just, maybe that's what it is. If they're throwing a party maybe, and they're putting tents, we would not want those tents to be straight up against the property line, again, for questions of stormwater, because we would not want these tents to be draining onto the neighbor's yard, and creating friction there with the neighbor. So yeah, that kind of makes sense. They would have to respect the setbacks as required, to bring some children's equipment, or maybe maybe they move something where it used to be located over there, and I decide that I'm going to have it here for the next 7 days instead because it's in my way. Yes, that kind of makes sense.
Okay. I mean, again, I just want us to also focus on things that we're more than likely going to run into. As an attorney, I appreciate the plan for the worst-case scenario, but I think what we really want to make sure they're most aware of are the regulations they are more than likely going to, violate. Okay, so then moving on to, I guess it would be page 13. Page 13, and why does it seem a little, oh, pardon me. 13, number 4, minimum vacation rental lease agreement wording. I wanted to ask if either yourself or Councilmember Fernandez could explain what this provision is meant to achieve.
While they're looking into that, I would venture to say that there are other municipalities that have this language in their ordinance as well, because in many of the properties that I've rented personally, this is all included in the lease agreement. they give you, I call it, the evening before I travel. It's like the workshop. We all have to sit down with all the paperwork, and you have to, in some places you can park on one side of the street on Monday, Wednesday, Friday. You have to park on the other side of the street on, Tuesday, Thursday, Saturday. They give you all of these things are included in your lease agreement, so that the person that is renting the property knows exactly how to behave, when to do things, when the garbage is picked up, so that you're collecting garbage, you're here for, 2 weeks, and you need to know that on Wednesday it's garbage day, because you don't know that it's Wednesday. So maybe it was taken from an ordinance in another municipality or in another area that had this language in it.
It's also kind of curious because it says vacation rental lease agreement shall contain the minimum information as provided for in this subsection. Then there's nothing else in that.
Oh, I was reading number 5.
Yeah, no, I'm looking at number
I
4.
interpreted number
Four.
5 as the subsection.
Yeah, and I think that Councilman Fernandez is driving at the core of where I was going with this, which is just simply, I'm not sure where it's,
Right.
that information is provided for, that they are supposed to include in the lease. And then I'm also curious what the interplay would be. Like, yes, you might rent directly from the owner, and on those written leases, you can go ahead and require this language. I'm curious how it would function, though, with a mobile application like Airbnb, how you would get, that wording in there. At least my experience with Airbnb one time in the Keys, everything was just, kind of like, okay, these are the house rules, whatever you agree, blah, blah. Maybe it was tucked somewhere in the terms and conditions, but, and maybe just Key Largo didn't have, this sort of requirement, but I'm just curious how that minimum wording would play into the, in a mobile application like that. But again, the main point is I didn't see that minimum information and minimum wording in the ordinance, so I thought it was a little vague for that reason.
Yeah, it may just be a vestige of wherever this came from.
And again, this is just a workshop, so this is just me identifying in more detail the aspects of that I found curious about the ordinance.
Councilman, one thing we can do is, and I'm agreeing with you, some of this is a little bit redundant, and some of it's a little vague, is we can go through a strike all on some of these items that are just a little bit more redundant, a little vague, and come back to you with a cleaner version on second read.
That's fine. I just want to flag them down.
No, and we appreciate that.
And that's why we were discussing before that the other sample ordinance that was presented that you brought in, the language was a little bit cleaner for that reason. At the same time, we do want to make sure that it has the minimums that cover, all the things that we want to be displayed in the property, all the information that we want the owner to collect about the lessees. I don't necessarily think we need to know every lessee at the time when they come in, but we would like them to keep information about who has stayed in the property, in the year, so that if something occurs, that something that happened 6 months ago, we can know who was the person that was occupying the property at that time. That kind of thing is important, right? So retroactive records be kept.
Okay. So are you suggesting that we remove this language entirely?
Yes, and maybe merged a little with the other one to make it a little more concise and a little less, right?
To merge with this sample? Does this sample have anything regarding what's to be included in the lease agreement?
No, and that's why that comes in, right?
Okay. I mean, I do think that there is value in all of these, in
Exactly.
requiring all of this, because you have someone that's coming in from Detroit. They have no idea what our lifestyle is here, or what's customary here, or they might not. I mean, we've vacationed in places where we have the garbage receptacles like in front of us, but we can't identify it because it looks so different. So it'll even tell you, there's a this kind of colored or a small brown box in the backyard, and that's where you're to drop off your garbage. I mean, all of those things they make the neighbors' lives easier, because then you don't have, like, if I can't identify what the garbage receptacle looks like, then I'm just going to leave the bag on the curb, or I'm going to leave. So I think that there's value. It might not need to be very, very specific, but I think that there still is some value to all of these, the local hospital, the non-emergency phone number to the police in case something happens. I think there's value to these things. I wouldn't remove them entirely.
Well, the reason why I would be in favor of removing at least that particular provision is that we're already, as we just discussed, we're talking about giving the occupants a list of the do's and don'ts, right, of the regulations that are expected. So I don't think you have to put in the lease necessarily. And again, they're still going to have to figure out how does this work with those mobile platform rentals, right? But again, we've already discussed them having to give the occupant a sheet of the regulations with respect to the setbacks that we just discussed, with respect to the stormwater regulations, trash pickup, et cetera. So, I mean, it might be redundant, to have in two places.
No, and I completely understand that, but and I guess I'm thinking about HOAs, and chances are that HOAs aren't going to allow these short-term rentals anyway, because even though town-wide we might have some things that we have in common, different communities, have differences. So if you're going to rent something in Loch Lomond, it might not be the same as if you're going to rent something for example, in West Lakes. There might be.
And it's always important to remember that HOAs make their own regulations based on the confines of our regulations, so it is up to them to change their regulations according to their deed restrictions.
Right,
and
but
it's not something
even in the communities that don't have, even in the communities that are
Correct.
outside HOAs, there may be differences that
Correct.
that might not be in that fact sheet, right? If we just give them like a Miami Lakes fact sheet, it might not be included in there.
Well, I think there's another way to solve that, though. I think I just went through as part of my new home purchase, going through our permitting department and everything. There's a part of the code there that was interesting, which is that you're required to notify the HOA of work. I mean, you don't need to necessarily get their approval, but to get the permit at least, you need to at least notify them. I imagine that was done because when we incorporated, the town was envisioned as a sort of master HOA with all the actual HOAs as kind of like sub-associations of the master, right? Maybe when they come in for the BTR, the owner has to provide notice to the HOA that they are going to be engaged in this activity. The HOA therefore can enforce their declarations if they need to, or permit it with conditions, whatever the case might be. But I just think that might be a more elegant solution in that
Yes.
situation.
Yes, I was gonna suggest something along that line, and there's actually that same form that the building department uses whenever you pull a permit, and it essentially says that you're responsible for checking with your HOA before commencing any work. The town, the town's approval process is independent of that, and so it's your responsibility to make sure. So I think something similar in our application process that says, this is the process for applying with the town, but it behooves you to check with your particular HOA. Not all HOAs even allow, short-term rentals. So, make sure that it's, check with your HOA before,
And
coming forward with
truthfully,
this.
this also gives them a little more teeth in order to be able to enforce their own regulations, because if we're not sort of backing them up, then it's difficult for them to, if there's somebody that decides to run an Airbnb within an HOA and they don't allow it, it's kind of hard for them to enforce it without.
If they're not aware or if they
Right.
find out after the fact.
Yeah,
I'm sorry. Correct me if I'm wrong. I think that there is a provision here in the proposed ordinance. It's registration required. In the registration requirements, subheading 9, when they register their property, they have to provide proof that notice has been provided to.
I'm
and
sorry,
written
John, what page is
consent has
that?
been given. Page 10.
Okay. And he said sub 9. So.
Right, so it's on that page, it's 9. So this is actually a requirement when they register the property with us, that they have to get approval from the HOA.
That's perfect.
Yeah, that's perfect. Thank you, John, for flagging that. Okay, so perfect. So that resolved itself. But again, as far as going back for a second to page 13 on that number 4, I just think that might be, as far as for purposes of making that be part of the lease, I just think that might be redundant compared to what we were talking about kind of having the owner certify he's going to provide this fact sheet, as it were, of the regulations that their tenant is expected to abide by. My 2 cents, at least.
Yeah, I would be in favor of striking 4.
Thank you. Let me see here.
Striking 4 and keeping 5?
Yes.
Yeah, at least on my notes, I did not have anything in 5, that I was specifically.
Because I think 4 is trying to say that the information has to be part of the lease, and 5 says that the person renting it has to be provided the information,
Correct.
just not as part of the
I
lease, just
understand.
in addition to
An addition,
the,
an
yeah.
additional sheet. I understood.
Correct.
Thank you.
Yeah, because that's how it goes into that earlier issue I mentioned about the setbacks. It's part of that sheet that has to provide all this information. Let me see here. Okay, now I'm looking at 8, and I'm not saying to strike it, I'm just saying that I'm curious if it may subject some people to liability that maybe otherwise should not. Bless you. In subsection 8 on page 14, where it talks about sexual offenders and sexual predators, it is unlawful to allow another person to occupy a residential property as a vacation rental within the town of Miami Lakes, knowing or should have known that it will be occupied by a person prohibited from establishing a permanent residence, Obviously, knowingly, of course. But I guess I'm curious, so through the chair, but through the chair to the attorneys, I guess that should have known part, like what would an example of that look like?
I mean, the owner needs to, or through the background search at least, find out or at least ask, these type of questions as, are you a known felon or do you have anything open? I mean, the one thing I can say about this particular section is this is something that has happened in the town before, I can say in recent, where someone has called and said, hey, look, someone's renting in a certain place, and I believe that they're a sex offender, and we actually, through our police department, found out that, yes, that was in fact happening. So having that in the actual code and having, in the actual, in our actual code, and having some provision which basically flags the owner of the property that, hey, look, you need to do at least some due diligence to make sure you're not renting this property to someone who may be a sex offender, I think is good. And it's worthwhile having.
Yeah, no, again, I wasn't saying to strike it. I just wanted, to kind of check it out and see if it wasn't unduly exposing somebody to legal liability who genuinely just had no idea that it was going on.
I think there should be some due diligence on their part, and
So-
that should have known.
So perhaps as part of, again, the BTR process that we're going to be establishing, requiring that they perform some kind of sexual offender registry search or something.
Right, and I think that goes a little bit to when we do the BTR receival, right? We receive the application annually. We would like to look at what agreement and what application they're going back and forth between them and the applicant to make sure that this question is asked. For example, there's a checkbox that says, I am not a sex offender, and nobody in my party is a sex offender, and that they check that box, and at least, it's a little random at the end of the day because they can just lie, right? And that's, but at least you are sort of notifying them that in the town of Miami Lakes, there's regulations as to where one can reside that is within so many feet of a school, within so many feet of a park or a church, and they may not be familiar with it because they may be coming from a place where those regulations do not exist. And
I have a question, and obviously I'm in favor of keeping this language in here. Do we require a similar process of our hotels? Right.
However, the hotels are regulated differently, and they go through a lot more scrupulous and much more scrutinizing regulation than anything that we're discussing here, where a lot of these things get flushed out by nature of the process of the hotel.
Right. I'm thinking more along the lines, and it's a little scope creep, but we're talking about hotels and homes that are treated as hotels, and it's a very slippery slope. But I don't know if we might want to consider at a future time making the traditional hotels post a notice of that,
Right.
you know, along those lines.
Yeah.
Particularly the ones that are obviously within 2,500 feet of a school.
Yeah, and remember that when you're talking about hotels, and again, Ms. Alonso touched on that. It's a different type of entity. It can't be a hotel. Just can't be in a residential zone. It's got to be a particular type of zone, and they have their own processes that they have to follow. We're talking about, and to keep the focus on, residential neighborhoods that are using their homes for short-term rentals. And the same rules that apply to someone who is leasing or buying and living should be applied to that person that is renting. And that's what we're talking about, I think, with this particular rule.
Thank you. And turning to page 10, very bottom, subsection A of 13-1633, it makes reference that the responsible party must be a natural person. I was wondering if you, Councilman Fernandez, would be okay with also amending that, not requiring that it be a natural person, but rather, that it could be, say, GRS management, and they'll eventually get somebody out there anyway, but the point is that they can designate GRS or some other property management company to be the party that is responsible for managing the rental.
Rather than an individual at GRS.
Well, because again, this is for purposes of designation, right? So like this is the person on file. So why can't they also just say GRS is my representative while I'm away, they're the responsible party. GRS obviously, if they have the contract, will go ahead and dispatch somebody in accordance with whatever the code requires. So I'm just saying, I think that would be helpful to allow some flexibility, that there be an entity also that can serve as a responsible party.
Yeah, I mean, I wouldn't be opposed to allowing for that. I think we might want to, in the case that it's not a natural person, we might also want to ask. Like we want to give them the option of not using the natural person, but we want the natural person maybe as a backup, so that we have, because it's and I'm sure you can attest to it, it's a lot more difficult to chase down a corporation than it is to chase on, Juanito that lives at, so-and-so address.
And I know Councilwoman Verano wants to jump in, but I'm going to make a quick joke about, our experience with a natural person. That's been a bit more difficult than the business, but.
Councilman, if you backing onto that, that would be okay if we were to also register GS, and I don't know what name you said, but GRS as a separate corporation that runs these kinds of operations, and we know what particular properties they're linked to. So that would be a double registration situation. I want to then register the Airbnb and that operator of multiple facilities separately and know what facilities they're linked to. And in that case, yes, that would be okay.
Well, I'm sorry, I took a quick phone call from my son. I think that part of what we're trying to do is dissuade companies like the flyer that you showed us in your presentation from coming in and saying, well, we'll manage all these Airbnbs in your town and we'll make this a big commercial movement in the town of Miami Lakes. This is something that we're looking to allow because, the state of Florida allows it and regulates it, but it's not something that we want to commercialize. So I think that, having a natural person on file that is responsible kind of, dissuades that movement of, the big management company that's going to come in and start sending flyers to every home and say, we'll manage your property, you can rent it out for 10 days, 15, whenever you're on vacation. And then it becomes, if it has to be a natural person, then it's more, at least for me, it seems like it's more having that individual be responsible for this particular property and doesn't put us in that predicament, I guess. I would be inclined to leaving it as a natural person.
Well, I'd put my thoughts on the record, and I'll leave it at that for now. But just what I will, before I move on to the next point, just for me at least, I understand we want to protect the character of our neighborhoods, but this is a permitted use, and I think we need to avoid being seen as intentionally trying to dissuade this sort of use, because it is permitted, and I think that sort of approach is exactly the sort of thing that will invite the state to want to step in and preempt further. But I understand your point. But again, I just think that, whether it happens organically and everybody in Miami Lakes suddenly, because suddenly all, because of the mall, because the mall shows up, now suddenly Miami Lakes becomes a premier destination to Airbnb, kind of like the beach and Miami. I think we're still going to run into the same issues. And again, what we're talking about is just who can we get to be responsive to the issues that arise at the property. I would argue an entity actually might be more responsive, and unlike an individual that you have to chase down, you're going to have a place of business that you can go and visit if they don't respond. Just food for thought. But I'll continue on in the interest of time. As a side note, and I'll go over this with the attorney later, and I had mentioned to him already before that there were some references that needed to be modified or deleted because they cited to incorrect provisions of the code. But we'll go over that. I already wrote them down.
Councilman Dieguez, while you go through your notes, and I know you've been very diligent, and I know this is something that you've added a lot of value to. I just want to bring up some points that I'm in particularly interested in, and it's not about the people who are going to follow the rules. I think we're adding a layer here of diligence, and I'm not concerned about the people who follow rules, because people who follow rules are not the problem. The people who are the problem are the people who are going to continue to ignore the rules, who are going to get the code enforcement violations, and they're going to throw them away. And I want to know what we're going to do against those people. The people who are going to be repeat offenders, the people who are going to continue to bring bad elements into the neighborhoods, because I still don't see enough teeth in here. And I apologize, because I've seen people who are chronic code violators, right, continue to accrue liens and continue to be a hardship on the neighborhood. So that's really what I want to build more teeth into this piece of legislation is what can we do against those people who are going to continue to create a nuisance in the neighborhood.
Yeah.
I think we're doing a good job of whipping the people who want to play by the rules, but I want to know, because there's only about a page and a half here, 2 pages, that talks about what we can do, and I want to know what we can do against those violators.
Yeah, as you know, Vice Mayor, we've had this discussion before about our initiative that the Attorney's Office is taking to start with commercial properties that have chronic liens, code enforcement liens. We also have that option open to us for foreclosure of code enforcement liens on non-homesteaded residential properties. So that would be the measure that we would take. That'd be obviously the extreme measure for somebody who is recalcitrant and non-compliant.
And that's exactly what I wanted to hear and be put on the record, that an extreme violation of this could ultimately lead to a foreclosure of your property and a property being removed from that person's interest. Thank you.
And I would even suggest perhaps even requiring a minimal bond at the time of registration, something that's not onerous that would dissuade them from engaging in a short-term rental, but something that's there, that at least will incentivize them to be on top of it. That way we're not just relying on liens that, again, they can, kind of push off.
I would definitely be in favor of that. Would we, Mr. Attorney, what is your legal opinion of the scenario that former Chair Blanco suggested about requiring that they relinquish or provide proof that they relinquish their homestead exemption?
I'd have to look into it. The problem that we have with the way that Florida law currently is that a lot of the issues, a lot of the area with short-term rentals has been preempted to the state. So I'd have to take a look if that's something that we could do.
Okay, thank you. And I think that would just make the kind of where I'm going with that is that would make enforcement easier, because now that, if you're now dealing with a non-homesteaded property, then it makes foreclosing on liens all the easier.
The determination of homestead is made by the property assessor, so we would have to basically tell them, hey, this is going on, and that is a dead strikeout if you're getting homestead exemption and you're renting the property out. It can be as much as a crime. I mean, that's a really serious thing to do.
Thank you. And there's a paragraph here that needs to be deleted at the very end on page 16. Only because it's already repeated earlier in the ordinance. But again, I'll go over that with the attorney. Now, my question to staff through the chair had to do with these suspensions of the BTR for violations of the maximum occupancy. My question there is simply that obviously that suspension follows the BTR that's been issued to the current owner, right? Like if the current owner has a violation and it's suspended, obviously the new owner comes in and they're able to pull a new BTR, right?
Correct.
Okay, just want to make sure it didn't follow the property, that it followed the owner. Okay. And I think I'm getting to the end here, guys, so bear with me. Try not to get too excited.
You have a PowerPoint you were going to pull up, weren't you?
Yes. So strap in, guys. Yeah, from what I can see here, it seems as if most of my concerns were either addressed earlier or we've already gone through them. Again, I just, especially with the setbacks thing, I was confused about that, and I'm here thinking like, okay, so if there's a building violation because they violated the setback requirement on a fence, the owner did, right, that we're going to hold the occupant, at least the way it was phrased, I felt like I left it open to that interpretation. So I think your explanation, though, added some clarity there. Posting of certificate of compliance. Okay. Okay, that's good. Well, then, yeah, actually, that covers it from me. I did want to let you all know, though, that I got a response back from my friend at Airbnb when I asked if their hosts are required to prove that they are registered with the state, per what we were talking about earlier, as far as, you know, did they have that information? And his response was technically no, because some of our users don't qualify as vacation rentals as defined in Florida Statute 509. And then he did indicate that they were open to a license and a registry. I think he was just also kind of confused when you know, when I started going through this ordinance with him, because again, I trust his input, is, you know, just like some of the other things that we already flagged about, you know, how would it work? And I think that's one of the biggest things I need you guys to kind of figure out is like, okay, some of these things are fine for written leases, but, you know, how does it work on a mobile platform? You know, for like the minimum terms and getting a copy of the lease agreement there. Like, are we going to, for those leases that, or those short-term rentals booked online or on the phone, what's the mechanism for us to get a copy of that agreement? I guess, so it's more logistical and practical.
Right, there's a logistics question, and obviously there's some procedures that will have to be worked out after we gel this into the right form. But in my head, the way it works right now is not so much that we would get every individual lease agreement that they go through, because that would be, like, I don't have time for that. That's way too much, right? But I would like to see, like, what are they using this year, for example? What is your lease agreement look like, your generic lease agreement, like a sample, correct? And we would like to see that it has the appropriate language that we're looking for. And if it doesn't, then we would say, well, you know, in order to get your BTR this year, we need you to add this into your generic lease agreement that you're giving to everybody. So no, we're not monitoring every one interaction. We're going to be monitoring all the interactions for the future year that you're starting when you register as a new user, right?
Yeah, that's fine by me. Again, I've provided my feedback to you guys. I think you've also received the feedback of my colleagues. So I'm just curious, or rather, I'll be expecting to see the revised product and hopefully also to answer how, not just the product, what it looks like once revised, but also how it's going to be implemented. Like, I want to know the plan of action, right? Because we can pass something, and then, but if we don't have the procedure in place to allow these owners and these operators to comply, then obviously, you know, we've basically, you know, imposed a rule that can't be enforced or is just not workable.
Right, that's why the BTR process is the one that makes the most sense, because that's already a process that we have in place for many other businesses, including the home-based business. You know, if you have a home-based business, you need to come and get a BTR in order to be able to hold it in your taxes. So this is something that is already in place, and it's a relatively simple process that we have procedures for. We just have to implement the particular procedures for this type of BTR, which would be just one more type on our system, and just fulfill the requirements.
Yeah, but just making sure, specifically what I'm referring to is just making sure that the information we're requesting from them at the time of pulling the BTR is information they're actually able to provide.
Correct,
Because, you know, and it's not something that they have to basically go to, corporate Airbnb and say, hey, I need a copy of the, terms of service that my guy or girl went ahead and checked the box for. So.
Okay, yeah, that makes sense.
All right, I'm done. I'm ready for the PowerPoint presentation.
Mr. Chair, I'd like to allow if any of the speakers that spoke during public comment want.
Yeah, no,
having heard
I saw several
the discussion.
individuals representing stakeholders, kind of having some feedback. And the floor, if you'd like, this is a more informal setting. As far as I'm concerned, you guys are professionals who have to work in the field and can provide some feedback.
Yeah, I mean, my concern is regarding the provisions of the lease, right? Because in Airbnb and those apps, there is no lease. So then, how will we enforce that?
That's what Councilman Diegues was bringing forward.
Right, and I say to Airbnbs, when you go to Airbnb, the owner is responsible for, complying with the local ordinances. So they make sure to tell the tenant what the local ordinances. You walk in, they have a check-in book, they have a list of rules. They have not only a list of rules, but also a list of conveniences. It's part of it's almost a culture of those type of rentals. So I would encourage you not to have a lease, because that's going to be very difficult
Right, and
to
maybe
enforce.
that's what it is. It's the word lease, because in Airbnb and in those mobile platforms or online platforms, there is a long, extensive list of information that is part of the rental of this property. So you're getting all exactly. So it might not be called a lease. Maybe we can call it lease terms or rental terms
agreement.
or.
And then also to the other point I want to bring to your attention is that, if you make the landlord ultimately responsible, it's the onus of the landlord to make sure his tenant is complying, and just make the landlord responsible, not necessarily. I mean, I don't know how you would enforce.
Absolutely, and I agree. That's a point that I was going to make earlier that I got sidetracked. Usually, there's a security deposit involved for any kind of fine that is incurred or whatnot, so the tenant is responsible financially. But I don't think that there's any mechanism by which the town can impose a fine on a transient tenant. It's only ultimately it's on the property. Exactly. Right. So the tenant will choose what kind of security deposit they want to enforce based on what they think may happen, and if it doesn't cover whatever damages as far as fines or violations are incurred, then that's on the owner. I agree wholeheartedly.
However, I have to say, and while yes, that is correct, we also have to be careful not to fit this too tightly to the existence of whatever apps are today, because that's just how it's happening today. Should the apps choose to unilaterally walk away from rating customers, then we would be holding the bag basically and not being able to take care of ourselves. So that's why we kind of have to be a little more generic, even though, right? Because we need to protect any future ideas they may have.
I do want to apologize. Throughout this meeting, Councilman Rodriguez has been with us online. And I know the mayor was with us for some time as well. Councilman Rodriguez, I know and there's the mayor. Do you guys have anything to add with respect to this particular issue?
Thank you, Vice Mayor. I don't have anything to add. I think my colleagues have really tackled this, specifically Councilman Dieguez, great job on pointing out most of the issues that really were of concern for me when we started looking at this ordinance. So I think you've massaged this into something that at least I can live with these changes that you've proposed. So, but I don't have anything further to add.
Yeah, no, I thank you, Vice Mayor, for that. And Councilman Rodriguez is absolutely right. I appreciate everybody that brought it forward. Councilman Fernandez, Councilman Dieguez, Susanna, the planner, our great intern now, who did a great job presenting today as well. And also Eddie Blanco and Danielle Blake, having those stakeholders, sit there and add their input as part of the discussion is phenomenal. I think you all did a great job, and bringing all that feedback together. I'm 100% in favor of it, because I know for a fact that it has to be regulated on the local level. I think we've all heard directly from our residents, and we're doing the right thing in responding to that. But to bring everybody's feedback together, especially those stakeholders, and having staff, having the council, I'm good with what I'm hearing. I've been listening to the entire discussion.
Thank you, Mayor. Thank you, Councilman Rodriguez. I don't know if we have any further comments, but I'm going to turn it back over to Councilman Fernandez and for your closing remarks.
Thank you, Vice Mayor. And I think this is a testament to we had a product. We voted on it in first hearing. We didn't get public input. Then we got the public input, and I'm a lot happier with the product that we've managed to that's come out of the process, right? And I think everybody's had a hand in improving it, and I think this is going to be a good ordinance for our residents. Thank you.
Thank you, Councilman Fernandez, and I want to echo the sentiment of the mayor. Thank you for all involved, especially the stakeholders that have taken the time to come out. Anytime that we have, and I think I shared this with the planner earlier, anytime that we make it a point to make sure that we have both sides in the room, the end product is much better. And I think we started taking some steps there. Let's see when it comes back. There's always the opportunity to get additional input, but I think this is definitely a step in the right direction. So thank you so much. Thank you for the time. And thank you, Councilman Fernandez, for the workshop. And thank you all the colleagues and everybody that's here that took the time. So hearing no further comments, workshop is closed. Thank you.
Good night.